Good afternoon, everybody, and welcome to Scott and Wallace Live, like we do every Tuesday here on Facebook Live. This is our chance to kind of talk to you about what's going on with our firm, to answer any questions you might have, and just to provide you all with some information that might help you all decide whether there's a case that our firm can potentially help you out with. Today, we wanted to talk about some employment law issues. As I'm sure some of you know in the past, my name is Matthew McNamara. I handle the firm's labor and employment division. I thought it'd be helpful today to kind of go over some interesting cases and intriguing cases that we've had here in the employment realm to kind of give you an idea of kind of the cases we take and some of the things to be on the lookout for.
And you might want to tell people why we moved inside this week, because you can hear all the music still going.
We're adjacent to a car audio store, so it was very loud out there. They were probably testing out their products or something, but they're working well. So we're inside today. Here to talk about some intriguing cases, again, just to kind of highlight some things that we do and help to maybe inform you about things that you should be on the lookout for with your job. One of the cases that is an intriguing one that we had related to the Florida Whistleblowers Act. As we've talked about before, Florida law makes it illegal for an employer to retaliate against an employee who reports some kind of illegal activity going on at their place of work. That illegal activity can be a violation of a Florida law, it can be a violation of a federal regulation, state regulation, any one of those things. In this case, for one of our cases, it was a violation of OSHA regulations. OSHA sets the workplace standards and for safety for most industries around the country. And in this case, we had a client who was working for a company who stored chemicals. As part of their storage of the chemicals, though, they weren't following OSHA guidelines. They were leaving them out, storing them improperly, and potentially exposing the employees there to risks associated with inhaling those chemicals or being around those chemicals. The individual contacted OSHA and filed an anonymous complaint, but because she had complained about it before, the company figured it was her who made the phone call about the OSHA violations, and she was terminated a few days thereafter. And in this situation, we were worried that, how would they know that she was the one who made the complaint? You know, she was able, when she made that phone call to OSHA, to kind of keep an ear to the ground and determine that she knew that co-workers were telling the supervisors there that it was her who called in. We were able to get a positive resolution for her, and it's a good situation because she did the right thing. Not only were she get a positive resolution, but the company itself had to correct their practices to make it safe for all of their employees there. Another type of claim we deal with a lot are just our typical discrimination claims. In this case, we had an ADA claim, which is the Americans with Disabilities Act. And an individual requested accommodations pursuant to the act given her a serious medical condition. Now, under the ADA, employers are required to make a reasonable accommodation if you have a serious medical condition. In this situation, she made the reasonable accommodations request, and the employer kept pushing her off, saying, yes, we understand, we're going to do that for you. But in reality, they weren't giving her the accommodation. In this case, it was a decreased workload so she'd go to her medical treatment and appointments. So although her employer was saying all the right things and saying that they were going to provide her the accommodation, when push came to shove, they never did, and she was forced to leave the company. Again, in that situation, although she was the one who left, their failure to accommodate her was the adverse action or the form of discrimination that took place that led to the company being liable for damages in that case. So if you're an individual who has an ADA claim and you request a reasonable accommodation, it's not enough for your employers to say we're going to get around to it. They need to actually go through an individualized process to assess whether they can make that accommodation happen. So those are just two examples of some intriguing cases where a little bit of, some issues related to the facts, and although the employer's trying to do what's right, or maybe the employer's trying to avoid liability, there's still protections in place for you. So don't ever assume that, they said that they were going to do this for me, so I probably don't have a case. And as always, any type of claim, whether it's a personal injury case, an employment case, or a workers' compensation case, feel free to give us a call, and we'd be happy to walk through those facts with you to tell you whether there's something we can do for you. Because oftentimes an individual may feel like there's nothing they can do, but when they sit down with an attorney and actually go over the facts and the law, they determine that there actually is some recourse for them available. So, we got any questions today?
No questions? No.
Okay. Well,
some thumbs up. Good job.
Okay, I like thumbs up.
Good information.
Good information. Good. Well, I'm glad everybody's tuning in, and as always, every Tuesday here on Facebook Live, tune in. Hopefully next week it won't just, you won't have to listen to just me. But every Tuesday when we're here, we'll have a new topic in the areas of law that we practice. And as always, feel free to give us a call here at 850-222-7777 if you have any questions. Thank you.